Professor Stoughton can speak to that. There's a national standard under Graham versus Connor. There's a standard of generally accepted police practices, and all of those fit into the constellation of what is objective reasonableness as viewed as a reasonable police officer on the scene.
Well, Sergeant Steiger spoke to Graham factors, and the chief spoke to Graham factors. Why do we need yet another person to talk about the Graham factors?
Your Honor, because he comes from a completely different perspective. And I think it's important to first focus on, when we're looking at exclusion, it'd be under Minnesota Rule 403. Cumulative evidence, it would be unduly cumulative, right? That would be unfairly cumulative, unnecessarily so. So you have to look at the importance of the relevant evidence here. The use of force, or authorized use of force, is a complete defense to all of the charges in this case. And so it is primary. It's at front and center. It's important that we counter what is sort of the Goldilocks syndrome in viewing expert witnesses. This witness is too old. This witness is just an administrator. This witness is not a national expert. This witness hasn't testified as an expert witness before, right? In order to be able to convince the jury, and we do have the sole burden of proof of doing so, that the use of force here was unauthorized and was objectively unreasonable, we need to come at it in a variety of ways. And Professor Stoughton is able to complete the last piece of that as through the eyes of a nationally recognized expert.
So what would he say? Let's get more specific. What specifically would Professor Dr. Stoughton say?
What he will testify is that upon evaluating both the threat or lack thereof posed by Mr. Floyd at the scene to the defendant and the other officers, both in terms of their own safety and thwarting law enforcement purposes, right? Based on that and based on nationally recognized best practices and police standards, the use of force here was objectively unreasonable. And he analyzes it both using Graham versus Connor, but in a four-part analysis where he identifies the force being used, he identifies the circumstances under which the force is used and the duration of the force. He looks at the effect, the effect of the force used by the officers as compared with sort of the threat posed by the subject, and then makes a determination whether that action was objectively reasonable under the circumstances. And so, it integrates Graham versus Connor, but it goes about it in a different manner, and it speaks to national and best practices standards. And it's important testimony, and it's a testimony that's central to the case.
Is your plan to show yet again the videos?
Certain segments of videos that are already in evidence as demonstrative, and these are very limited in duration, Your Honor. I'm not having him play through an entire video and comment on each and everything. What he is going to be doing is in the same manner in which he analyzes and reviews cases. So, the threat, for example, or lack thereof posed by Mr. Floyd, he would be talking about specific segments of the video that he thought were key to his analysis for that. And we select those, and they're 5-second clip, 8-second clip, not an extended play. And then going through the next portion of the analysis and also commenting on whether or not the bystanders would have had an effect on a reasonable officer. We highlight certain portions of those clips too, in a not necessarily chronological order, but in an orderly fashion. I expect that his testimony won't last on direct more than 90 minutes. So it's not going to be exhaustive play of this. Now, that's important because having read the report of the defense expert, Barry Broad, who is expected to testify, central to his report is that the crowd so distracted the defendant that he was unable to render aid and perform the normal duties that he would as a law enforcement officer. And so it's important to that issue as well, and that's an issue that's been certainly raised and suggested by the defense throughout this trial.
All right. Well, court's concern was pretty clear before, is that in motions eliminated, said we're not going to call every cop and ask him what would you have done differently, and basically I think the state has almost done that. We now have opinions from the chief, the inspector who was in charge of training, the lieutenant who was in charge of training, Lieutenant Zimmerman because of his seniority and that he was the responding lieutenant on the scene, the sergeant. I think the state has made its own bed here by deciding to ask all those people what their opinion was as opposed to sticking with their experts. So I think the defense has a legitimate concern, and I have a concern that this is becoming cumulative. As far as use of force, since it is more from an academic point of view and national standards, I'll allow you to call Dr. Stoughton to talk about national standards and how the use of force here violated them. I'm not going to allow you to do the crowd effect on his opinion. It's really pushing the extremes of his expertise. He's the use of force expert. He can mention that he didn't think the crowd in this case was, but he's not going to get into was a factor. He's aware of it. He didn't think it was a factor, and he can give an opinion as to whether or not the defendant violated national standards. But I don't want him getting into separate opinions about generally the existence of crowds, and he can talk about he's aware in this case about the crowd effect, and that does not change his opinion. But we're not getting into small crowds, large crowds. This is how you would deal with large crowds. I don't want to get into that again. To the extent the defense, I'm probably giving more than the state deserves by allowing you to talk about national standards and his opinion in this case, whether they were violated, and he can talk about how he took the crowd into effect. But I don't want him talking about, like some of the experts did, about small crowds, large crowds, all that.
This specific crowd.
Exactly.
I will limit it to his this specific crowd, this specific event. We're going to be looking at the specific events here, not hypotheticals, just the timeline, his examples, and then his opinions.
All right.
Your Honor, as to the phenomena of auditory pareidolia, as the supplemental report that we gave to the defense, this is raised by the questioning of both expert Jody Steiger and of lead investigator James Ryerson, in which the defense introduced, it would exhibit 1007, I believe, and asked witnesses to opine based on what he first suggested that Mr. Floyd said. Mm-hmm. And Professor Stoughton, because he reviews so many body-worn camera cases and has an expertise in that, and has lectured on this topic before of the phenomenon of suggestibility or auditory pareidolia, he would be able to provide not only testimony about the suggestibility and why a witness may have answered a question in a particular way, he would be able to provide an example of this. We have a demonstrative of that particular segment, slowed down, supplemented with a transcript, and it would suggest he said something completely different. Ultimately, Professor Stoughton would indicate that when he listened to the portion several times without suggestion, he was unable to discern what precisely was said.
Mr. Nelson, you want to respond to that part, since I don't think we talked much about
that? Your Honor, again, I believe that this is within the province of the jury to decide what was said. The state has already, after I asked those questions of Mr. Ryerson, they took Agent Ryerson into the hall. He listened and he formed a different opinion about what was said. And so, first and foremost, this is an issue within the province of the jury. What was said, what wasn't said, they can listen to it. They're going to be provided with the exhibits in this particular case. So it is within their province, not the expertise for him to come in. It's also important, I think, Judge, that the exhibit that they have intended to, or they've provided me that they intend to offer, is a very slowed down with subtitles showing what they believe or they think it could potentially be saying or could be interpreted as saying. So again, we've not had any opportunity within the last 48 hours to analyze what it is that they've done, to have an expert to combat it, or to have anybody. This was completely out of left field, in my opinion. So, and given the court's previous orders on expert witnesses, I mean, what the state has done throughout the course of this case is they've introduced segments, they've attributed statements to various witnesses where certain things, you don't know if it's Officer King saying something, you don't know if it's Officer Lane saying something. You know, the jury's not had the jury's just being told by the state, this is who's saying this. So it's the defense's right to introduce doubt, and at this point, the late hour on it is problematic.
Well, on top of which, I think it's very much a collateral issue, but I'm going to grant the request to exclude that testimony. It's not a proper topic for expert testimony. The video is what it is. The jury can listen to it. They can make up their own mind. In fact, to be honest, I was surprised that there was not an objection when Mr. Nelson asked the witness, isn't he saying X, Y, and Z? That's a witness opining on a videotape, telling the jury what they should see or hear. And that's not a proper topic for expert testimony. And the fact that you had to slow it down and use subtitles, I think, is just an indication that this is not a proper topic. It's for the jury to decide. They can listen to it. I mean, I have experience in listening to a lot of body-worn cameras. That doesn't make me an expert. I have to make factual findings off and off of body-worn cameras in Rasmussen hearings. Doesn't make me an expert, nor is it appropriate that I would, when I sit listening to body-worn cameras, I'm doing so as a finder of fact, just like this jury should. So they're going to have to listen to it on their own. They're going to have to figure it out. Both sides can argue. And both sides got their point across anyway. Agent Ryerson said, yeah, it does say I eat too many drugs. And on redirect said, putting it in context, I think it was, I ain't do any drugs. So both sides have had their say, which probably was better off in closing. But in any case, you're not going to be allowed to ask him about that stuff. Other motions we had, I think, we have Mr. Hall. We're going to deal with Mr. Hall, put him on the stand and have him either invoke and for me to determine whether or not to each specific question if it's an appropriate invocation or not. But we're doing that tomorrow, I believe. But for now, the question is, assuming Mr. Hall does not answer any questions, refuses either on Fifth Amendment grounds or just refuses the court's order, what did you wish to introduce, Mr. Nelson, and what's the basis for admissibility?
Your Honor, Mr. Hall provided an interview to Agent Doug Henning of the Minnesota Bureau of Criminal Apprehension and Agent Ricky Worry of the Minnesota Bureau of Criminal Apprehension. After the incident on May 25th, Mr. Hall left the state of Minnesota, returned to Texas, was ultimately apprehended based on some warrants that existed, was apprehended in the state of Texas, and Agents Henning and Worry traveled to Texas to interview him. At that time, I would note that Mr. Hall had an attorney who was present and was giving him advice as to providing statements about this particular incident. The statement that he provided included, just to give context of the statement was approximately an hour and a half long. He freely answered the agent's questions about where he and Mr. Floyd spent the day, what their behaviors were, where they went, the things that they did earlier in the day, and specifically how he appeared physically, what his demeanor was, etc. He then provided information to Agents Henning and Worry relevant to being in cup foods, his observations of Mr. Floyd in cup foods, and his observations of Mr. Floyd in the car prior to the arrival of Officers King and Lane. What Mr. Hall described was that instantaneously it was it was day and night difference essentially in his behavior. He fell asleep. They were concerned. They didn't understand why they weren't driving. Then all of this, he describes the interaction with the two witnesses who've previously testified, the store employees who've testified. He describes that they had to try to shake Mr. Floyd awake several times. And then obviously he gives testimony about what happened afterwards. There were questions about by the agents about whether Mr. Floyd had consumed any substances, controlled substances. Mr. Hall opined that that was, at least in part, what was going on. He had discussions with Mr. Floyd about how these particular pills made him feel, and largely attributes his falling asleep to taking these pills.
In that statement, did Mr. Hall admit that he had provided those drugs to Mr. Floyd?
No, he was specifically asked that question by the agents. Did you give him these pills? And he said no. That was his response.
Okay.
And then he obviously goes on to describe what happens after the officers arrived in the initial detainment and his interactions with Peter Chang of the Minneapolis Park Police. And so he paints a picture of what was happening before the incident, immediately preceding the incident, and as the incident was occurring. And what reactions were happening. So we would offer, if Mr. Hall invokes his blanket or a blanket sort of invocation of the Fifth Amendment, Your Honor, I believe first and foremost the court has to analyze the defendant's, Mr. Chauvin's, right to present a complete defense and the constitutional law that stems from the right to present a complete defense when it contradicts with another person or conflicts with another person's right against self-incrimination. I also believe that Mr. Chauvin has a right to confront any witnesses that would be available to him, including trying to build his defense through those types of witnesses. Number three, the state has gone to great lengths to establish that fentanyl or controlled substances did not play a role in Mr. Floyd's death, and the state is the only party to this that has the ability to offer Mr. Floyd immunity, use immunity. Well, the court can't order it, I can't request it, but they have, at least in the chamber's discussions, stated that they do not intend to offer Mr. Hall immunity for his statements. So I think the state would have to make a showing or an offer of proof as to why they are not intending to offer Mr. Hall use immunity, at a very minimum use immunity of this statement. And the specific grounds, or what we would propose, is similar to what the court did in State versus Super, S-U-P-E-R, and I can get the site for you in a second. And in State versus Super, it was a similar circumstance where the defendant was charged with premeditated first-degree murder. A witness invoked her Fifth Amendment privileges. The state refused immunity, and ultimately what the court permitted was playing the witness's statement in court to the jury, so playing the audio of the witness's statement. And that's what we would be proposing, is to call Agent Henning to come in, explain the circumstances of the interview, to play portions of the interview that are ruled appropriate by the court, and we would offer those under Minnesota Rule of Evidence 804B3, which is a statement against penal interest, or 807, which is the residual exception, which is what the court used in the Super case, was the residual exception.
Well, let me stop you there. 804B3, the statement inherently has to clearly subject the person to such that the person who's making the statement knows that they are throwing themselves in the soup, so to speak.
Understood. And as you heard from Miss Cousins, I believe, Adrian Cousins, Mr. Hall's lawyer here, the third-degree homicide charge is a potential charge that Mr. Hall could face if he specifically provided, exchanged, bartered, or had any knowledge of what was going on. The court has now also seen the evidence of Mr. Hall throwing what appears to be some package off to his side while the police were dealing with Mr. Floyd. So if you look at the circumstances of this statement, I mean, it would certainly be, if he were to be charged, it would certainly be a statement about what was happening in that car. And circumstantially, and from a bare minimum, it would be impeachment if he were to get up and testify that he didn't provide Mr. Floyd with the controlled substances. So, I mean, according to Mr. Hall's public defender, even acknowledging his presence, or that was him in the video, or that was him with Mr. Floyd on that date, certainly could potentially tend to incriminate him. I mean, they say everything about this case, about his testimony, could incriminate him.
Well, are you saying that the testimony that would be that he could legitimately refuse to answer on Fifth Amendment grounds, and the evidence that's admissible under 804b3 are the same?
Yes.
The same universe? Okay.
Because ultimately, Judge, if you look at the sum total, when Mr. Hall made this statement, right, which was June 2nd of 2020, so within a week, he was located and apprehended and interviewed. He was counseled by a competent attorney who gave the blessing to speak about what happened to Mr. Floyd on that day. But if you go back out and you look at, there were pills found in the car, there's a video of him throwing something, there are above and beyond just the third-degree controlled substance crimes, they do ask him questions about giving false identity. He gave Officer Lane an actual driver's license or ID card with someone's name on it. He then gave Peter Chang a secondary name, so he can be incriminating himself.
Did he admit all that in the statement?
He did.
Okay.
He had warrants for his arrest that were in place at that time, issued by the state of Minnesota, and he explains in that statement that he has had problems with the warrants, which is why he took off out of town. That's ultimately why he was apprehended as well. So he had multiple layers of. He acknowledges in the statement having a counterfeit $20 bill in his possession. So in the course of this statement, he makes several incriminating statements outside of this particular incident. As it pertains to whether he provided Mr. Floyd with the drugs, he denies it, right? I mean, he says, I didn't do it. And, if that is his position, based on how the questions that the state has presented, they intend to impeach him if he were to testify in this case with that statement. I mean, so they're using some of the very things that he claimed in his statement to either impeach him or to attack his credibility. So certainly, I think that the state has taken the position that Mr. Hall's testimony or his statement was not credible to these investigators. They have the ability to, again, offer him use immunity, if that is their position, that the controlled substance had played no part in this case. So, when we look at, again, a defendant has a right to present a complete defense. And so when we start from that analysis, that would include investigation of facts that are exculpatory or that are consistent with his defense. And that's what this is. We look at the residual exception in terms of the 807, in terms of the trustworthiness of this statement. There are several aspects of this statement that are corroborated by Ms. Shawanda Hill. So particularly when describing Mr. Floyd's reaction in the car, she also describes that Mr. Floyd fell asleep in the car and was they had a very difficult time waking him up. So much so that she called her daughter to come and pick her up. She makes statements about Mr. Floyd taking Percocets. So there is, above and beyond that, Mr. Hall was counseled by his attorney about this case and giving this statement. So,
And let me just, and maybe this is an argumentative question, well, I don't mean it to be. So you're saying that his lawyer, who was advising him at the time of his statement, advised his client to give a statement that was so far contrary to his penal interests that it's admissible under 804b3?
well, I mean, to that end, the lawyer was a Texas lawyer and may not have been familiar with Minnesota's third-degree homicide statute.
Fair enough. All right, who from the state would like to answer? Mr. Frank.
Good morning, Your Honor. Thank you.
Good morning.
I think the court clearly sees that sort of the conflict that counsel is presenting here in saying that there are issues that Mr. Hall can testify about legitimately despite a Fifth Amendment claim, and yet those same statements are not what establish the trustworthiness that the statement against interest requires. In other words, counsel is saying Mr. Hall made statements against his interest, but those are not the statements he's trying to have Mr. Hall testify about. The statements he wants Mr. Hall to testify about, that he has asked the court to allow despite the invocation of the Fifth Amendment, are not the statements against interest. To step back just a minute, counsel argues that he has a constitutional right to present a defense. That's true, but there are tons of cases that recognize that's true, but defendants still have to follow the rules of evidence. The rules of evidence, the hearsay rules, have to be satisfied for the statements that counsel wants to come in through Mr. Hall, despite a Fifth Amendment invocation, are covered. And the statement against interest, counsel relies on all the statements that he doesn't intend to introduce. And for purposes of the sort of catch-all exception, well, incidentally, before I get there, the statement against interest in criminal cases also requires some indication of trustworthiness before they can be admitted in a criminal case.
Well, isn't that taken care of by a court finding that it is so far contrary to the person's penal interests? That's the reliability part. Otherwise, we would have needed the second part of the rule, which says that if it's an inculpatory statement but exculpates another, you have to have corroboration. That same corroboration requirement does not seem to apply to the first sentence. And I say that to just note that it's almost saying it has to be, it's corroborated or it is considered reliable because it is so clearly and far contrary to a person's penal interest.
The statement against interest has an additional requirement in criminal cases, and that is some indication of trustworthiness for the entire statement. So it's similar to the analysis under the sort of catch-all exception, 807. And, there's a lot about Mr. Hall's statement that is self-serving and unreliable.
For example?
I'm sorry?
For example?
For example, he denies giving any pills to Mr. Floyd, denies that he had pills. We know a lot of that is not, there's a lot of evidence that suggests that's not true. He gave false information at the scene at least twice. He did flee from Minnesota and had to be apprehended in Texas. He gave very sketchy details about his own involvement. He denied having any fake money, passing any fake money. So there are a lot of reasons to doubt Mr. Hall's credibility when analyzing the entire giving of this statement. It's very self-serving, obviously. And
What are your thoughts regarding the body of evidence that would be considered that he could legitimately take a Fifth Amendment claim of compelled self-incrimination versus, is it smaller, larger, or as counsel said, the same group of factors that fall under 804b3 statement against penal interest?
that's I think the primary point I was trying to make. The evidence that counsel thinks can come in despite the invocation of the Fifth Amendment, none of that is a statement against interest. It's a description he had of others, of Mr. Floyd. That's not implicating himself and thereby not creating a statement against interest or something that would implicate him beyond the obvious fact that he is present. He's present in a vehicle where drugs are present. There are indications that he may not have been truthful when he said he didn't give Mr. Floyd any pills and may not have been aware of that. And in our proposed questions, he will have to be asked if he was under the influence of any controlled substances that day, because it fundamentally affects his ability to know, remember, and relate. And that, I think, we will have then potentially an invocation just on that question alone. But that sphere of evidence counsel wants to put in through Mr. Hall does not constitute a statement against interest. Other statements he made, through which I think even the court realizes he would have the right to invoke the Fifth Amendment, are what counsel is claiming are these statements against interest. So the statements he wants in don't fit under that exception. They're just plain hearsay. And so that's the fundamental problem that we have with trying to limit this sphere of information to come out of Mr. Floyd, or to come out of Mr. Hall, is that they're not a statement against interest.
All right. What I'm going to do is I'm going to take this under advisement until after lunch. I'll look at the super case and consider counsel's arguments, and I'll give you a ruling at 1 o'clock before we bring the jury back. Mr.
Site for super.
Yes, please.
7. It's at 781 Northwest 2D 390, Minnesota Court of Appeals, 2010.
All right. I'll take a look at that and consider counsel's arguments, and we'll come back at.
Your Honor, and for purposes, just for clarification, is in terms of the questions that I provided to the court, you had, as I understood the court's instructions, we were limiting those questions to just in the car.
Correct.
Time frame in the car. That's the basis. The statement that Agent Henning took that I would intend to potentially play would be more of a description because of what they did that day.
Right. Understood. Okay. Any other motions we have to deal with this morning? Otherwise, we should start up with the jury.
Yes, Your Honor. The discussion we had in chambers relevant to last night's events.
Do you have a motion?
Make it
Let's do it.
Yes, Your Honor. At this time, I am requesting, again, sequestration of the jury in view of the incidents of last night. As the court, I'm sure, is aware, an officer-involved shooting took place in the city of Brooklyn Center, Minnesota. As a result of that, there was some fairly extensive civil unrest that occurred. I would note for the court that we have at least one juror who's a resident of that particular city, and other jurors who have connections to Brooklyn Center. Given that this is obviously a high-profile case, this is a case that evokes a lot of emotion for a lot of people. Ultimately, Your Honor, the question becomes: will the jury be confident to make a decision regardless of the potential outcome of their decision? There's two possible verdicts here, right? Guilty or not guilty. And my concern is that these jurors, and it's been an ongoing concern, that a juror in Hennepin County being exposed extensively to the media before coming in and serving as a juror, being at least initially cautioned only to avoid news about this particular incident. We've questioned one juror already about whether she had seen some particular pieces of information that had not been presented in court. She, I felt, had credible responses to the court. But ultimately, this incident, while it is, I understand it's not this case. I understand that it does not involve these same parties. But the problem is that the emotional response that case creates sets the stage for a jury to say, I'm not going to vote not guilty because I'm concerned about the outcome. During voir dire, we had many jurors who, on both sides of the political or social debate, who expressed concern about if they don't agree, if the public doesn't agree with the verdict. This incident last night highlights, and I think brings it to the forefront of the jury's mindset, that a verdict in this case is going to have consequences, and they've been exposed to that already. So at this point, I would request that the court further voir dire, first and foremost, further voir dire jurors as to whether or not they have learned of this, because some jurors may be completely avoiding the media and some may not. So we should, I believe, first voir dire jurors to see what, if anything, they have learned about last night's events. Second, whether those events would have any impact on their decision-making process or concerns about their decision-making process. I think that the jury should be sequestered. I think that the jury should have been sequestered. I've made that clear in previous discussions and motions. I think the jury should have been sequestered throughout the pendency of this trial. And I think that the jury needs to be cautioned at the beginning of every day and at the end of every day to avoid all media. Again, we've had discussions about that in chambers. So I believe, Your Honor, that at a bare minimum, that's what should happen.
All right, does the state have a position?
Yes, Your Honor, thank you. The state opposes the motion for sequestration. I don't believe that sequestration would be a remedy that would be appropriate or, frankly, effective in this matter. As counsel pointed out, it's a different case. It's a different department. It is an officer-involved shooting. It is something that happened nearby. We really don't know what the facts of the case are at this particular point as those things are unfolding. But world events happen. Things continue to happen in the state, despite the fact that we're all here in trial. That's just what happens. And we can't have every single world event that might affect somebody's attitude or emotional state or anything be the grounds to come back and re-voir dire all the jurors. The court, in our voir dire process, we asked the jurors, specifically the issue that Mr. Nelson is concerned about, whether they would be so concerned about the outcome of a verdict that they wouldn't be unable to be fair and impartial and render either a guilty or not guilty verdict. And all of the jurors who were sworn and impaneled said that they would be able to do that. And the court will further instruct them that they are to do that. They're to render their verdict without regard to the result. And the law presumes that jurors follow the court's instructions, and we should presume that they meant what they said when they said it, that they could set aside these external issues and decide the case based solely on the evidence. So I think it would be inappropriate to voir dire jurors now about events that, while related and being on the same topic of the case, do not involve this case. In terms of sequestration, I don't think that would be an effective remedy. Again, as far as the court admonishing the jurors to avoid all media, I don't oppose that request. I think that it does present some issues. If you order the jurors to avoid all media, it's very difficult to avoid all media. And we'd have to tightly define what does avoid all media mean. Years ago it used to mean don't read the newspaper, don't watch TV. It means something different now, I suppose. Media comes at us in all different forms. I think it'd be very difficult to follow an order to avoid all media. And while it might have the effect of reducing the media contact, I wouldn't want to have a situation where then, if a juror inadvertently received some media on some unrelated thing, that would be a grounds of, claiming juror misconduct because they didn't follow what would be, a nearly impossible court order. So I think the court could fashion some guidance as to what to do. You could encourage them to avoid all media. You could even order them to do it, but if something inadvertently filters through, I think we can't overreact to it. I think we'd have to look at that on an individual basis, just like you did with the other juror question that we had the other day, and we found out that it really wasn't what we thought it could have been.
I'm going to deny the motion to sequester the jury and for additional voir dire. This is a totally different case. And I realize there's civil unrest, and maybe some of the jurors did hear about that. The reason why in my initial order I said we're not going to sequester, but we might go to it in the middle of trial if, and the concern there was that despite keeping jurors anonymous, that somebody may find out who one of the jurors is and reach out and have an inappropriate attempt to tamper with the jury. We have no indication that that's happened in this case, and that was the concern about going to sequestration. I understand the argument from the defense that this now puts them even more ill at ease, but I think sequestering them would only aggravate that. Oh, I heard about the civil unrest and now the judge is putting us into sequestration. There must be a greater threat to our security. I think the better way is to just continue with the trial as we've been going, that's a separate issue. They should treat it as such. It'd be a different story if it was civil unrest following another verdict, where the jury can see what the consequence of a certain verdict might be in a similar case, but that's not this case. The jurors all are aware and we're concerned about their safety because of what happened in May of 2020, the civil unrest that followed there. Not a big surprise that there's now civil unrest in response to this case, but I don't think that should heighten the jurors' concern. I think it's probably the same as it was before. They all have a concern that they expressed and were very honest about. And so I'm not going to sequester them. We'll sequester them on Monday when we anticipate doing closings. And we'll proceed accordingly. So with that, let's bring in the jury.